Today we want to discuss pitfalls of the NIW, specifically why generalizations fail in 2025. This is kind of an emerging topic. We saw it before, but especially following that January 2025 policy update from the USCIS regarding the NIW petition evidentiary requirements. We are definitely seeing more complications or more challenges for evidentiary requirement. That is why generalizations typically fail. But let's get into a more in-depth discussion of what this means and how to overcome it. So in previous Monday live sessions, we have discussed the importance of tailoring your proposed endeavor to your specific expertise, to your specific niche within your practice area. And the reason that we emphasize this is because we want the proposed endeavor to highlight what you have intended to achieve in your future plans in the United States. This allows us to then align the substantial merit and national importance. We can also show how it's imperative with more clear, concise language. It ensures that the officer is able to more easily understand the content, more able to appreciate the niche aspect of it or the unique attributes that it may be delivering to the United States. In this presentation, it is for educational purposes only. It's not intended to be legal advice. It's not intended to be, very specific information. These are general concepts that we're discussing today, and we just want to take a moment to remind you of that. We will be able to provide, broad information to this crowd today. And the importance of specific NIW proposed endeavors, we also want them to be concise. This includes what we call SMART goals. SMART goals stands for having specific, measurable, achievable, and time-bound goals, and they can be broken down into short-term and long-term objectives. A detailed description of the methodologies, the advanced skills that you will be using to achieve your goals is imperative. And making a clear connection to that national interest. We want to show the USCIS that it is imperative that your objectives get executed in the United States, and it is in the United States' best interest to approve this petition based on the alignment to, we want to make a clear connection to a U.S. interest in that proposed endeavor. So that leads us to pitfalls. And why did I start with the proposed endeavor? And the reason that I started with the proposed endeavor first is because that is where the backbone of the petition is formatted. If you're familiar with the NIW, you know that you have to have a prerequisite education, and you know that there's a three-factor analysis. And so how is that all evaluated? Well, it's evaluated against that proposed endeavor, which is a common misconception of the NIW. So that is why I started off with the importance of a specific, concise, and clear proposed endeavor leveraging SMART goals. So that leads us to pitfalls. So these pitfalls that we're going to discuss, they will weaken your proposed endeavor. They often are the most common reasons for the NOIDS, RFEs, or a denial. And these issues are something that they're easy to fix, but they also require a lot of focus. They require a lot of engagement with clients, and typically it's not something that an attorney can overcome without participation with the client. The reason being, we are not experts in your field. And that comes through. It reduces authenticity. It reduces the specificity that an expert can provide about their own skills, about their own plans. You know your plans best, and therefore that's how this kind of relationship becomes highly imperative through this process. So let's talk about pitfalls. We mentioned vague and overly broad description of your work and goals. We don't want this to simply be a continuation of a job you are already performing in the United States. We want it to come across it should come across more of research. It should come across more as project and collaboration and societal impact. And so simply continuing your job seems passive to the USCIS. A lot of times you can continue your job as a means to executing the proposed endeavor, but we have to be cautious and make sure that, it's being framed in a way that it isn't seeming passive to the USCIS. We want to have active engagement. So that leads us to the next thing about we want you to have narrow impact. Or narrow impact meaning a narrow focus, so a specialization. But we need to have a broader impact so that it's clear that it will reach the broader United States on a national level. We don't want it to just simply align to your current employer's objectives, because the USCIS does not find that even a global employer, if you're simply aligning to their objectives, they don't find that company objectives are necessarily national objectives. And so we're seeing those kicked out right now for that reason too. Similarly, kind of dovetailing off of that is failing to draw a clear connection to national interests. Again, company interests are sometimes driven by national interests. They're sometimes driven by federal initiatives that are active, federal funding. However, private companies tend to have their own objectives as well. They're trying to do things that benefit their bottom line at the end of the day. So with that in mind, failing to show alignment to national interests could be a reason for, weakness in a proposed endeavor or a petition itself. Focusing on the importance of the field rather than the petitioner's contributions. And I like this one a lot. And I'll use the example of AI, or artificial intelligence, as you may know it. As we know, the digital interface is touching a lot of industries, right? Most industries are having to transform for this digital interface that is coming through. And so the USCIS doesn't have to be sold on the value of a digital interface in multiple industries. They don't need that confirmation. What they are focused on is making sure that your specific contributions to your field are of value and of national interest, and that you're well positioned to do so, and that there's an urgency to support the approval of an NIW. So if you think about it in contrast, you don't have to sell the benefit of AI to the United States. What you need to sell, or what you need to portray in your proposed endeavor, is your contributions to AI. Is it in the healthcare sector? Is it in the telecommunications sector? Is it in, public health? Like, what are you doing specifically with the proposed endeavor? And it can't be that you're doing everything across the board. The USCIS has rejected that position. So that's what we mean when we say focusing on the importance of the field itself rather than the petitioner's actual contributions. There can be a distinction there. They can go hand in hand, but we should always prioritize that petitioner's contributions, and making sure that the proposed endeavor that you provide also does that. We want it to highlight your unique skill set, your unique contributions, and your unique plans for enhancing the industry and the nation at large. So lastly, the common pitfall that we're seeing right now is insufficient evidence. So the USCIS is pushing back for higher evidence. They are rejecting kind of what I call softer evidence in support of petitions. They are wanting to see measurable impacts. They're no longer excited by, memberships alone, high salary alone, or letters of recommendation, kind of giving broad generalizations. They're really wanting specific objectives that the petitioner has achieved. They're wanting to see how they have distinguished themselves and created themselves to be an impetus in their field. So that is an ongoing standard that the USCIS is challenging petitioners to achieve at this time. So is your work being honored in media formats, recognition of some kind? Are you receiving promotions based on merit, not just, years of service, but actual merit? Are you receiving performance-based recognition for your contributions? Are you, publishing publications in peer-reviewed journals that are then being cited by other industry leaders? If so, then, those are all stronger pieces of evidence that can support, um, the USCIS in finding stronger ties to your proposed endeavor, stronger ties to that well-positioned aspect, and your national importance. So keep in mind that evidence could change case by case depending on, we want to leverage the things that are the strongest for you in your specific endeavor, in your specific industry. Take a look at your resume. That's a great place to start if you are looking for maybe evidence that could help build your petition or get an idea of what evidence you may need. Taking a look at awards you've received, publications you've been awarded, or other kinds of salary earnings is a great place to start. And I've pulled some questions today. I think that sometimes questions and answers is a great way to kind of learn a little bit. So I've pulled a few questions for you today. The first question is, can I use some the same proposed endeavor that someone else used if we are from the same field? I like this question because it's asked more times than it surprised me by the number of times I'm asked this question. And the answer is it depends. That's a classic attorney question, response. However, it's unlikely that any one proposed endeavor could really work for a second person. And the reason is because the NIW is such a unique visa. It has a pathway that's based on authenticity, on your own being an impetus in your field. And if multiple people are doing the same thing, how does that show that you are an impetus in your field if you're doing the exact same thing? So typically I don't encourage it. I think that that's probably a bad approach, generally speaking, because you lose that ability to be authentic in your role. You lose that ability to sustain, a narrative that's really true to your skills and your attributes. And honestly, at the end of the day, that's where a proposed endeavor can really distinguish itself if it is authentic. They can tell someone who's very passionate, very skilled right away. That conveyance of the information, the details, the plans, it all comes across with a lot of just authority and just passion and a declaration of expertise that's just more undeniable. So for that reason, I don't encourage reusing proposed endeavors from friends or roommates or that you get online. I encourage you to craft your own with the help of a legal expert is probably best, but otherwise I would encourage you to really keep it authentic to yourself. And this question is coming up more and more also. For someone who has never worked in the United States, you talked about being specific. How do I prove my work helps the United States? And I like this question because it is imperative. You can have a proposed endeavor that has national importance, that has, alignment to things that the U.S. is caring about, that you have experience to support your proposed endeavor. But at the end of the day, if your work abroad hasn't already benefited the United States, then it can kind of weigh down on that third prong, which has to show urgency and that you've already benefited the United States in some way. So how do you do that? And the answer is it will depend on your expertise. It will depend on your personal trajectory. But generally, what we need to do is create a narrative or an understanding of how your work has benefited the United States, either directly or directly from abroad. If you haven't worked on international or national level projects in your home country, it's typically not likely that you would be able to meet this threshold. So that's something to consider also. However, those of you who are working abroad and you're working on, I just worked with somebody who was an engineer at an international organization, and we were able to look at his company's relationships with U.S. initiatives. They had direct relationships with U.S. for the oil and gas industry, direct relationships for an engineering industry, direct, they were developing technology and software together is what we found. And so we were able to leverage that pretty successfully for the client. And then what I'm getting at is that there are a number of international relationships that we can successfully leverage, we can successfully lean on. But this general acknowledgement here that if you're not working on national level projects in your home country, it's unlikely that you would have met the international level. Typically, national level projects are the ones that touch international contributions. So again, it's a case-by-case basis, but that's a great place to start with assessing your work. And this question is interesting also. It says, can I apply with a bachelor's degree from Bangladesh? And the answer to that is that it depends on your work experience and other skills. Typically, a bachelor's degree alone is not sufficient for the NIW educational requirement. However, there is an exceptional ability framework. It's a 6-factor analysis that you can get with a bachelor's degree in 5 years progressive contributions. It's a higher threshold. It's a little bit more difficult. There's 6 factors. You have to meet 3 of those 6. I won't say it's impossible. There are some people who have done a really great job. They have a really great portfolio that's prepared them. But I would say that there's a higher threshold or a heightened scrutiny for demonstrating that you truly are an impetus within your field. If you choose to do that route, we have to make it very, very clear to the USCIS that you do distinguish yourself, that you have a high salary, you either have a license or a degree, you have awards, recognition, memberships, contributions to your field that have had a measurable outcome. So all of that gets assessed, up front in the exceptional ability prong, but also again, throughout the rest of the petition, we can leverage that information for other issues such as like the well position. Some of the national importance can come in with that as well. And this question is, can I write that I want to start a company or build a product in the United States? Will that help or hurt my case? And I like this because there are a lot of entrepreneurs or people who are aspiring to be an entrepreneur to reach that broader impact requirement of their proposed endeavor. And I think that this is a pertinent question because entrepreneurship is allowed. It's not that it's not allowed. But what I like to caution is that it will be reviewed as, if you choose entrepreneurial skills for your short-term goals, you will be evaluated as an entrepreneur and as an expert in whatever your field is. And so I tend to find that if you want to do something entrepreneurial, given the logistics of, you'd have to take a look at your visa, whatever visa you're on, the constraints you're on, the financial feasibility. You would have to take a look at all of that information and, argue that not only are you in a position to be a successful entrepreneur, but you're also in a position to be a successful expert in your field. And I think that's typically a threshold that's not sustainable for most people. So typically, I encourage that could be a long-term objective. It can be one of your long-term objectives. I don't typically recommend it as a short-term objective. Of course, there's always going to be exceptions. There's somebody who is probably watching this who has maybe extensive entrepreneurial skills, and that could be grounds for possible exception to that. But generally speaking, while it is permitted to have entrepreneurial skills in your proposed endeavor, I typically don't encourage it as a short-term goal. It can be part of your long-term portfolio, though. This question asks, can I mention collaborations I want to pursue in the future, even if they are not confirmed yet? And I think that it's typically great advice here. You can always mention collaborations that you want to have, but it's more probative to the USCIS if there's also letters to go with it that says, hey, your proposed endeavor focused on public health research, an email from the NIH that just says, hey, you know, we're looking forward to collaborating with you in the future on your research focused on, you know, whatever public health issue you're looking for, any kind of award, recognition of collaboration is much more probative than simply saying this is what I will do or this is what I want to do. It's certainly helpful information to say, you know, these are my future plans for collaboration, but having some kind of traction toward achieving that collaboration already in hand is much more probative to the USCIS. It's much more compelling to them that you can actually achieve this, and it's not just some kind of dream that you're coming up with without an actual, you know, kind of direction put in the work or to make the connections or earn whatever collaboration you may be seeking. It also is helpful if you are already an employee at you know, a nonprofit or some kind of federal agency that is focused in your field of expertise. If you've already been invited into past projects, it tends to be well received that it's likely that you're already in connection with, you know, the channels that would allow you to have future collaborations. So I think that this could be helpful to say, I specifically plan to collaborate with these entities or these agencies or these nonprofits, but it's even more compelling to have already had some experience and to have some evidence to support their interest and or your past experience.